So thank you very much for inviting me to Chorus. It's been nice to see Chorus emerge and develop, and I think you're doing exciting work, and this is no better time than to study Korean politics than right now. So I guess in talking to John, some of the discussion was, tell us a little bit about your research. This book is coming out in June. It'll be my second monograph. So obviously I can't tell you in 20 minutes or so about the whole book, but I'll give you a flavor of some of the research and the main argument of it. So the book is titled From Manners to Rules, Advocating for Legalism in South Korea and Japan. It compares South Korea and Japan, mainly looking at the emergence of legalism, which I'll define in a second, through two issue areas, through disability rights and tobacco control. And within each of those two issue areas, there are two types of reforms. So mobility rights and accessibility and disability policy, and then disability discrimination law. I will not talk so much today about tobacco control, but I'm happy to take questions on that. Not next week, but the week after that, I'll be getting page proofs for this book, so it's like finally almost out. This book has been like almost 8-9 years in the making. It basically attempts to document and explain a significant transformation in the role of law and courts in Korean and Japanese politics. Specifically, the emergence of more detailed and more enforceable laws that can be used more effectively in court, and also more formal and proceduralized policy design and policy implementation procedures. And all those changes, that basket of changes, is what scholars have called legalism. So Korea and Japan are kind of hard cases. They were known for a long time for not having legalism in the way that they governance happened. So you had lots of informal, non-binding measures like recommendations in laws, closed door policymaking, often in smoke-filled rooms, and vague or often changing, especially in Korea, laws. So especially under the dictators, they would change the law to suit whatever their needs were. Rather than rule of law, you had rule by law, and it changed according to the leader's preferences. So historically, non-legalistic governance characterized Korea and Japan. There were also lots of structural disincentives to using the courts to influence policy. There were very few lawyers. The state capped the number of lawyers that there could be. And also, litigation took a long time. You could only expect a limited reward at the end. Probably the classic example of the unenforceable soft law tools that dominated historically in Korea and Japan are smoking manners posters. So rather than regulate where you could smoke, you had posters that said, try not to annoy people when you smoke. So these are some examples. The green and white ones funded by Japan Tobacco. So the industry was very much in favor of keeping manners as the main mode of regulation, not having enforceable laws. But more and more on the streets, literally on the ground in Japan, you're seeing law emerge. In Korea, here are some examples that many of you may have seen. On these new regulation posters, you also have the enforceability, the fine that's attached with rule breaking. And so this is a good visual example of legalism emerging in Korea and here in Japan. And then for those of you who read Japanese, the picture here says mana de wa naku ruru desu. So it's not a matter of manners, it's the rule. In Japan and the Ministry of Health, Labor, and Welfare, they use this phrase mana kara ruru, from manners to rules. And that is where I'm drawing my book title from. So to describe this shift towards more legalism. The main questions of this book are how is regulatory style changing and why? So what's changing and why? Should we do a brief round of introductions with the three people that just joined? Or
Yeah.
can you introduce yourselves briefly?
Oh, yeah.
Your name, grade, or not grade, but
I'm Tianzuo Jiang. I'm from Beijing, China, and I'm very interested in North Korea studies and studies and also the content.
Nice to meet you.
Nice to meet you.
What?
Interaction design in corporate.
Oh.
Tianzuo.
Okay.
Hi, my name is Benny Kim.
Nice to meet you.
Nice to meet you as well. I'm an international affairs major, and political science, and a sophomore.
Okay. You're the famous other Benny.
Oh yeah.
Hi,
Right,
so nice
Emma.
to meet you. My name is Emma Park, and I'm a double major in political science and international business here, and I'm a freshman currently. And I'm so sorry we're late.
No
It was-
worries.
it was just
The shuttle was
Yeah.
challenging. You said IA and poli-sci?
Not IB.
IB?
Yeah.
Okay. Sorry. Nice to meet you all.
Yeah, I'll be your MC today.
That's good. Thank you. So feel free to stop me when I've talked for too long. As I mentioned, this is a whole book, so I could talk for like 5 more hours about it, but I will try not to. Okay, so to describe what is changing, what the dependent variable of this book is, I use the concept of legalism that Bob Kagan came up with. So he talks about the who and the how of policymaking. That's what legalism describes. Policymaking that is detailed, that involves detailed written down laws with that decision makers follow pre-existing rules when making decisions and procedures when they're implementing policy. That formality is one characteristic dimension of legalism. And then the other characteristic dimension of legalism is that it's participatory. So rather than decision-making being by bureaucrats in a closed-door room, decision-making is more contested and open to different parties. Okay. Legalism is related to the other concepts that have been gaining traction, which are legalization and the judicialization of politics. And so if you have legalism, basically that sets the legal frameworks off of which judicialization is possible. So these are kind of adjacent concepts. This is a very scientific graph of the book's the change that the book is trying to describe. So Korea and Japan are heading towards more legal, they're having a legalistic turn in their regulatory style. Question is why? So some indicators that legalism include more formal and detailed rules, more codified rights written down in the law, more sanctions or fines for rule breakers, like those smoking fines that I showed you earlier, more participatory policy making, and more proceduralized enforcement, including through the courts. And so one common term in both Korean and Japanese, the 의무화, or making things obligatory, in Japanese gimuka, you see all over the debates about tobacco control and disability rights, and that's one indicator of this legalistic turn. So as I said previously, we're in the realm of non-legalistic governance. So people with disabilities in Korea and Japan had to rely on the goodwill and good intentions, for example, of station staff, if they wanted to try to use public transportation. In Korea, people with disabilities argued that good intentions were not enough. Here, the express buses, intercity buses, were totally not accessible, and so they protested at those to try to demonstrate that disabled persons also want to ride the bus, and they should be made accessible. There should be a law that requires these buses to be accessible. Some of the protesters in Seoul, again, kept demanding that those steps that you all are very familiar with outside cafes be abolished so that you can actually get into the cafe. To make this a little bit more concrete, this change, in the last 20 years, Korean disability policy, so accessibility and rules about anti-discrimination for people with disabilities, became much more formal and much more participatory. So in 2005, there was a law passed that codified for the first time 이동권, or the right to mobility. Also, the majority of members of the Policy Coordination Committee for Persons with Disabilities have to be disabled individuals themselves, so more participation, a seat at the table. And in 2007, the Disability Discrimination Prohibition Act, or the 장애인차별철폐연대, was passed, which specified that if you experience discrimination, you take your claim to the National Human Rights Commission, and if that is not followed, then you can take it to the courts. So again, it became more formal, the procedure, how do you remedy discrimination. Also, since 2015, the system for checking if buildings are complying with regulations about accessibility requires disabled persons to be on the committee that checks the buildings. So again, more participatory, more formalized procedures. And since 2022, new buses, when they're introduced, have to be accessible, except for the inner city buses, which is an interesting problem. And it used to be 300 square meters or smaller didn't have to be accessible, which meant that 95% of convenience stores in Korea were inaccessible or were exempt from the regulations. Now 50 square meters or smaller have to be, or are exempt. Okay, similar changes in Japan. I'm not going to go into all of those details, but I'm happy to talk more. This legalistic turn is not just happening in Korea and Japan. So for example, Dan Kellerman uses the term Euro-legalism to describe the process of integrating Europe's legal systems into an EU-wide system. And even in China, Mary Gallagher has used the term authoritarian legality to talk about how the Chinese government has increased legalism. Okay, most of the existing explanations for this legalism tend to be top-down. So they say either that political elites are opting for legalistic policy solutions because they expect to lose the next election and they want to tie their successors' hands, or they're trying to deal with institutional fragmentation in lots of different administrative units, so they want more legalistic, more formal, and more participatory regulatory style. Some have also talked about how foreign pressure, including with international treaties, pushes political elites to adopt legalistic policy instruments. Likewise, judges, in particular Korean Constitutional Court, has supported legalistic policy solutions through its rulings and made them kind of stick more because they are trying to bolster themselves as a newer institution. My argument, however, is bottom up, that activists and lawyers are societal drivers behind the legalistic turn, that they're demanding more laws, more legalistic policy solutions, and they're actively using them, which strengthens those legalistic changes. So they not only demand laws that define rights and specify enforcement mechanisms, but they then also take them to the courts or monitor their implementation and deepen them. Okay, so they are helping to make governance more legalistic. Okay, a key actor in my book are cause lawyers. So these are activist lawyers who help draft and legislative reforms. They investigate the human rights conditions to show the need for more legalistic laws and regulations. They are also enhancing civil society organizations. They help pursue strategic litigation, and they monitor Korea's compliance with international treaties like the Convention on the Rights of Persons with Disabilities. In Korea, some of those organizations may be familiar to you. Konggam, for example, also a small public interest law firm called Himang Mandaeun Pop. There's a issue-specific legal expert association, and the large law firms have established public interest law foundations. Tongcheon and Turu are the most active on disability rights. And the lawyers that I talked to say that it used to be that the lawyers would volunteer if they were interested in disability law. Now they could actually earn a salary for doing disability law through these public interest law firms and foundations. So part of the difference with Japan is that public interest law firms and foundations do not exist in Japan. And so Korea has a better support structure institutionalized for promoting legalism. Okay, my book details these 5 ways through which lawyers and activists are contributing to legalism, and I'll just give you a couple of examples of the 2 that are highlighted in yellow: information subsidies and strategic litigation. So the point of causal mechanisms, which you may have learned in your poli-sci classes, is to say why does A cause B, or how in particular. And so these mechanisms spell out the ways in which activists and lawyers are contributing toward changing regulatory style. Okay, so to give you an example of information subsidies, the Korean Solidarity, the Disability Discrimination Act Solidarity of Korea, was formed in 2003, and they established a legislation committee to try to pass a law prohibiting disability-based discrimination. On that committee, you had people with disabilities and lawyers, and some lawyers with disabilities. That committee went around the country holding public hearings with disabled persons organizations and gathered data about what types of discrimination people experience. And then they used that to draft a law, which they then proposed to the Korean Democratic Labor Party, which is the far left tiny party at the time. And that was then proposed to the National Assembly. The authors of that bill said that 90% of the law that they wrote was actually in the bill that was proposed in the National Assembly. So this is a good example of how they bring information subsidies to make the law more likely or easier to pass. So National Assembly members have limited time, knowledge, staff, and if the disabled persons organizations and lawyers can shoulder the burden of collecting data and writing up a coherent law, that helps make that law more likely to pass. That solidarity also had protests out in the streets in 2006 and 2007, including a sit-in at the National Human Rights Commission of Korea. So it was not just this bill. There was lots of other activity going on. But the bill, because it was proposed by the tiny left-wing party, did not get passed. However, it remained a document. And when the Nomuhyun government formed a task force to create a disability discrimination law, they pulled that document back out and said, oh, this makes sense. And that became the starting point for the law that was then passed in 2007. I'm going to skip the Japanese examples of information subsidies and tell you just a little bit more about another mechanism through which activists and lawyers are contributing to legalism, and that is kind of testing the laws and showing where they have loopholes. So I mentioned that there are exemptions from the regulations about the accessibility of facilities. The Pyeongi, if you want to get really into the weeds, required only places that were 300 square meters or larger to be accessible until 2022. The lawyers and disabled persons organizations realized that cafes, convenience stores, hotels were all exempt from those regulations and therefore often inaccessible. And so they got together in 2018 with just 4 plaintiffs and about 20 lawyers, and they filed a lawsuit against Shilla Hotel, Tusum Cafe, and GS25, the 3 largest in each of those sectors. That lawsuit was challenging the enforcement decree of the Convenient Facilities Act. Even though Korea signed on to the Convention on the Rights of Persons with Disabilities in 2007 and had this law prohibiting disability discrimination since 2007, it still did not revise that enforcement decree. And so the lawsuit was challenging, was about legislative negligence or inaction for 24 years. It had not been revised. And really interesting, last December, some other things were happening, but the Supreme Court ruled for the very first time a case that the legislative branch had failed to act, and that was unconstitutional and illegal. They not only won this case, but the plaintiffs also got compensation from this case. So it obviously did not get a lot of news coverage because of martial law and other things that were going on, but it's a really, really significant ruling. Again, the first time that the court found legislative inaction to have been illegal. Along the way, from 2018 to 2024, as this court case was working through the courts, I think it was Shilla Hotel settled, and they decided to voluntarily make their hotels more accessible. And Tusum Cafe did as well. GS25 decided to keep fighting in court. But the enforcement decree was revised in 2022, so before the court ruling. But the fact of filing the lawsuit helped bring about that change in the enforcement decree. So then now the only exempt places are 50 square meters or less. The phrase of this lawsuit was 일층의 삶, like everybody can live on the first floor, which echoes back to a life with dinner, which was a labor activist slogan to try to make reasonable work hours back in the 80s. Here are some pictures of what the lawyers did alongside the court case. But what they've also done is not just filed this lawsuit, but used that movement to create with a foundation. They have basically a way of providing subsidies to small businesses to install these types of ramps. So they're trying to not just use the courts, but also address the problem by teaching local businesses how to make their places more accessible. So here's another picture of the Supreme Court in October. And this 모두의 1층 has become a key phrase, or 1층의 삶. And these are pictures from January in the National Assembly, trying to think about what next steps, now that this court ruling has happened, how can we finally abolish all exemptions for size-based regulations. And part of why this lawsuit was so successful is that these public interest law firms and foundations have created a network of sharing know-how and strategizing about how to best tackle difficult remaining problems in the law regarding disabled persons. So for example, since 2015, the 장애우 권익 문제 연구소, I think it is, has been publishing an annual report about all the cases related to disabilities from that year. Some were steps forward, some were steps back. And they analyzed those court cases. Also, about 30 lawyers volunteer at a legal advice hotline where you can call in or consult with lawyers through a disabled persons organization. And so they're building networks and know-how and also solving people's real-world problems and helping to deepen the law and make it more useful in some ways. And one of the other ways that they're doing this is to advise the court administration on how to make judicial proceedings more accessible. So for example, Turu has been going around the country to most courthouses with disabled persons and testing out how accessible courthouses are. So can you get into the courthouse? In the courtroom, are there movable chairs? Is there closed captioning? Can interpreters come in? Is there video capabilities and things like that? As a result, to give you a sense of how helpful the public interest law firms and foundations have been compared to Japan, which doesn't have them, Japan's judicial guidelines for persons with disabilities are 12 pages long, and the revised Korean version is now 225 pages long. And these are non-binding, so this is not technically legalism, but these are advice, guidelines for the courts about how to make their buildings, their procedures more accessible. Okay, so basically what my book does is it documents this shift in regulatory style towards more legalism, where in countries where law was long considered marginal or a tool of the dictators. And it theorizes the mechanisms through which lawyers and activists are changing regulatory style or contributing to changes in regulatory style. And in particular highlights how disability cause lawyers are playing a key role in this process. Okay. Thank you.